Barcelona. So thank you. And without further ado, I would like to move to the topic of our today's meeting, which is the recent reform of the European contract law, European private law of 2018-2019. My remarks will be based on the paper I published recently in the Yearbook of European Law at the Oxford University Press. I hope all of you had a chance to get access to this paper and at least go briefly through what I was trying to say through this piece. Basically, the idea I had for this paper was to somehow reverse engineer the intellectual conceptual premises of the bunch of new acts, new provisions of the European consumer law, European private law that were introduced a few years ago within this reform. And as you could see in my paper, I was trying to tackle upon a few issues, amongst them in particular the sustainability concerns and online contracting, digital contracts, digital sphere of commerce. For the sake of today's presentation, I would like to focus principally on the online contracting, on the online focus of this reform of European private law. However, if any of you would have any questions concerning sustainability or the other issues I will discuss in this paper, I will be happy to address them as well. Okay, so now let me shift to my slides. I hope you can all see them right now. And of course, I'm not going to summarize at length the entire paper, but what I would like to do in this introductory part to our meeting is to somehow pinpoint the most interesting or most important, from my perspective, parts of the paper that perhaps may tell us something new or something provocative about the direction towards which the European contract law is now heading, and about the possible both present and future changes in the approach of the European private law regulation of EU market with regard to the online contracts. And first of all, what my paper is about and why I decided to write the paper and frame it in the way as it was framed. So as you probably all know, the European contract law experienced a very profound change in the past years, and this change was triggered by more general shifts in the regulatory focus of the European Commission. So the European Commission started to put more emphasis on the issues related to protection of environment, to the green policy on the European single market and common market. And secondly, European Commission started putting more and more emphasis on the online commerce, on the digital sphere of communication, on processing and gathering data, and so forth. And this resulted in a chain of events, which was initiated in 2017 by the so-called refit of consumer law, which was a profound overview of the existing rules in the sphere of consumer law, and which resulted in a study which was identifying some areas which both requires some reform and as well which requires some kind of more regulatory focus. So these were both the areas that are already regulated by the EU and which should be somehow reconsidered in terms of the regulatory toolbox. And secondly, these were the areas where the European Union was advised to conquer new territories with its own regulation of its rules. This Fabra led to the policy paper, to the blueprint for the Fabra legislative actions, which was the New Deal for Consumers of 2018. And later on, it resulted in a chain in a bunch of new acts of the EU contract law, EU consumer law enacted in 2018, 2019. And in my paper, I discussed several of these acts. Most important of them are the 3 directives you can see on the slide right now, which are the directives considering the digital content, considering the reform of the sales law, and the so-called Omnibus Directive, which was sort of a horizontal instrument which was reforming several pieces of the EU consumer regulation, including the Directive on Consumer Rights. And most of the things that happened in terms of digital commerce, in terms of new approach towards online contracting, happened indeed in the frames of the reform of the Consumer Rights Directive. The three general aims or focuses of this reform were, first of all, the sustainability, secondly, the online commerce, and thirdly, a more effective enforcement of consumer rights. And my paper, as you know, has a subtitle, a triptych. And why? Because I thought, and this is again something we may further discuss upon. I will be very happy to hear your views, your voices about it. But from my vantage point, the 3 most important parts in which this reform really intervened into the conceptual theoretical framework of European private law were, first of all, the concept of vulnerability. So the concept of who is vulnerable, who should be protected, who deserves more paternalistic or at least more attentive treatment from the European consumer or European contract law. Secondly, there was the question of autonomy. So how the autonomy is understood and what kind of autonomy the European contract law is protecting after this reform. And thirdly, the question of regulation. So it's more than the first 2 problems. The third one is more focused on some theory of market steering and the concept of how European economy, especially consumer economy, should be regulated and what kind of shift we could experience in this sphere. And now moving to the first of these elements of this triptych, I would like to say very briefly what I thought is the most important, the most conspicuous change in terms of the concept of vulnerability. So the concept of vulnerability has been discussed for a long time in the European private law scholarship, and many scholars, and I share this view as well, tend to understand vulnerability as a broader concept, as a broader notion than weakness. So although weakness is more or less understood as weakness considering the inferiority, superiority between parties to the particular contract, vulnerability is understood in broader, in more ample terms, by referring to various structural market and social institutions, contingencies, which make one party inferior, weaker, more vulnerable towards the other. And from this perspective, vulnerability departs from this classical notion of weakness, which is based mostly in European private law, mostly on the classical institutional economy vantage point, which is that consumers are, or the weaker parties to contracts are those parties who do not have enough information, who cannot incur high transaction costs and so far. But it moves more towards the underlying social and economic fabric of the consumer commerce. And from this point of view, some traces of this approach in the classical European contract law we may observe in, for example, Unfair Commercial Practices Directive, where such factors like some social inequalities, age, gender, and so far are to some extent taken into consideration in evaluating which part to the contract may be vulnerable, which party may be manipulated, which party may be subjected to some kind of strong unlawful influence from the side of the contractor, of the other party. But of course, this approach was very slowly making its way in thinking about European private law until the last reforms, until the 2018-2019 new set of legislation. And what is also important here, and what is also important for the current debate over European private law, is that in its classic terms, in its classic understanding, vulnerability, even more strongly than weakness, was perceived both implicitly and explicitly as the equalizing factor on the market. So as a sort of response that the contract law can give, or a sort of like the conceptual framing within which European contract law may respond to some underlying inequalities, disbalances between parties, and inequalities which may be rooted also in some social or economic inequalities in the society. And now, what happened after the reform? So first of all, after the reform, the vulnerability started to be understood even more broadly than it was understood before, because when we look into the new directives, the object of protection or the justification of a protection is no longer the weakness which may manifest itself on the grounds of particular contracts, but it's weakness which can also be related to the private sphere, to some individual goods, individual values of the person. And from this perspective, perhaps one of the most clear, conspicuous spheres in which this kind of overlap, this kind of, let's say, enhancement of the concept of vulnerability is visible, is the sphere of protection of privacy and protection of data. Because as you know, there are several links between data protection, between GDPR and consumer law. And this is quite obvious right now. Even it was obvious even before the 2018-19 reform. But right now it's quite clear that European consumer law, contract law in the EU is trying to protect not only individuals who make particular contracts, but also individuals who may be subjected to various kinds of influence from the market, understood as the let's say, general concept of professional participants to the economic structure. So European consumer law is more and more concerned with protection of privacy, with protection of individuals whose privacy, whose data may be somehow invaded, may be infringed, even without any contract, any actual transaction, any actual economic weakness or economic vulnerability at stake. Secondly, and also within these frames, again, perhaps one of the other clear examples for this kind of concerns is the question of personalization. Both price personalization and personalization of preferences, for example, regarding the personalized advertising, where European contract law is again trying to protect something more than simply economic utility or economic welfare of individuals within the particular transaction. So the focus here is much more shifted upon the autonomy, upon guarantees for the sovereignty of individuals, of individual consumers vis-a-vis firms, than on guaranteeing, safeguarding that particular contracts will be fair, will be just, will be efficient economically for the for consumers. Again, from this perspective, the concept of vulnerability is also understood, or at least it seems it is understood by the EU law after the reform in more broader broader terms, also considering the kind of interest that is involved in this sort of considerations. So, as opposed to the classical structures of European consumer law, which were mostly focused on protection of individual interests of consumers who make transactions, or at least who involve in some kind of market interaction with professionals. Currently, European consumer law is also interested in protecting something which we may frame as social order, social welfare, social stability, and which is quite often something different or something more than just individual interests of consumers who act on the market. And from this perspective, again, when we think about data protection, or when we think about privacy protection or personalization, perhaps the actual harm that can be done through, for example, mishandling of somebody's data or invading somebody's privacy is much more as a harm to the social welfare or social order or the stability of let's say, the social and market constitution of the particular society than the actual harm that has been done to the individual consumer whose data has been abused, has been mishandled. So in other terms, it seems that European contract law is more and more interested in more collective-oriented, collectivistic thinking than it used to be before. And it's more and more interested in providing some stable and well-framed rules for the social and market interactions, not only in providing that these rules will be actually enforced or will be actually respected in particular individual contracts. So again, it seems that there is more and more of this general collective perspective rather than focus on individual transactions. And here, if you, perhaps there will be more time to discuss it in the Q&A, but here I'm very much into the argument which was presented quite recently by Professor Omid Ben-Shahar from the Chicago Law School, who in the paper Data Pollution quite clearly and quite convincingly, from my perspective, claim that protection of data and all the privacy concerns are much more the issue of some collective goods than the issue of individuals whose data has been actually harmed or actually infringed or mishandled by firms, by professionals on the market. And now moving to the second part of the triptych, so autonomy. As we may perfectly understand, and it goes without saying, perhaps, for us, the classical autonomy concept in the EU consumer law has been based on rather orthodox understanding built on the premises of institutional economics. So on the considerations related to information asymmetries, to transaction costs, to bargaining power, and so far and so on. Later on, European contract law experienced to some extent the behavioral revolution, which added up to this picture, the awareness that there are multiple individual factors that may influence the decision-making processes of both individuals and groups of individuals on the market, and which do not always clearly fit into this classical institutional picture. But still, the concept of autonomy in European consumer law used to be based on the, let's say, more or less economic-oriented focus on individual contracts, on individual utility, and autonomy in this within these frames was considered rather as the possibility of the individual to make sovereign, informed choices about his or her economic situation and the possibility of an individual to pursue his or her own economic utility, rather than any other kind of autonomy in any other sphere, except for the economic relations, economic matters. However, when we think about again what happened after the reform, this is first of all the clear overlap between the concept of the new concept or novel concept of autonomy and the concept of vulnerability. So this more enhanced, broader concept of autonomy, of vulnerability I was trying to describe before. Secondly, in the consequence, the reform seems to favor blur the lines between private and public law, or public and private toolbox, which, as you know, in European Union law were already quite vague and non-consequent. And right now it seems that both structurally, formally, but also functionally, there is more and more considerations we tend to think as public law problems introduced into the sphere of private law. And one of them for sure is the question of protection of data. The other one, which is also discussed in my paper, is the question of sustainability and the idea that contract law may be used as one of the instruments for pursuing protection of environment, for pursuing sustainable development, and so far. And finally, which is also very important for the reform, and I think this is also quite revolutionary when we look at how European contract law used to look like before, is the idea that autonomy after the reform is considered not only as the autonomy to make contract efficient and to make market decisions that particular consumer wants for himself or herself. But secondly, but apart from this, there is also the autonomy regarded as autonomy for preserving one's self, private sphere, information about oneself, and so far and so on. So let's say from the I would say anthropologic perspective that is underpinning this reform, consumers are no longer considered as these like economic creatures, Homo economicus, who act on the market and whose only goal, or at least only legally relevant goal, is to make efficient, well-framed market transactions. But consumers are also considered as those who, by getting involved in the market, risk some values or some assets that should not be taken into consideration in market dealing. So, for example, some sensitive personal data, some sense of privacy, and so far and so on. And again, here, when we look into GDPR, when we look into some particular elements, for example, of the reform of the Consumer Rights Directive, we may find many examples, for example, considering the personalization of prices, where European contract law is trying to quite clearly protect consumers, not only in economic terms, but also as this, in terms of this protection of one's self, of the some kind of like information integrity and privacy related integrity of consumers. And finally, the third element, so regulation. And here, as I said at the beginning, I was especially concerned with the question of how the reform of European contract law is approaching the question of regulation, and to what extent this reform is trying to reframe or reconsider what we used to have in European contract law. And as you know, classically, European contract law was very regulatory, as perhaps Hans Miklitz would frame it. It was very regulatory, was very much based on the idea of private law as the ordering instrument, not as a purely enabling device, which was, let's say, the non-European, traditional perception of, for example, contract law. Secondly, the European contract law is much more based on mandatory rules than default rules. And again, here there was, as we all know, a big distinction between European contract law and the classical domestic contract law, which to the opposite was dominated by default rules. And what is also very important is that the classical notion of European contract law was based on something I called here as a single vector regulation. So the idea that we have some sovereign political power, like the domestic, like a member state, or the European Union agenda body, European Commission, and so far and so on, which is vested in the power of regulating the markets. So there was this rather classical conviction of what are the sources of contract law, who may make contract law, and how to recognize what is binding, what is not binding in the sphere of contract law. And on the side, the classical regulatory picture of European contract law was also quite directly based on the idea that contract law, especially consumer protection law, but also we may trace this approach elsewhere, for example, in the regulation of commercial intermediaries, that European contract law may have not only allocative effects, but also distributive effects. So that European contract law may lead to some shifts in allocation of goods, of assets on the market. And now, again, what changed? So first of all, perhaps one of the most important changes here, as we may perceive when we look at the new acts in the sphere of European contract law, is the change of optics in perception of the sources of European contract law, because quite clearly after the reform, European contract law is considered as a part of a more pluralistic and more diversified regulatory environment or normative environment than it used to be before. And here, in the newly enacted acts, we can come across many examples of this approach. Perhaps the most conspicuous, the most vivid ones are, first of all, the rules on the supply chains, and secondly, the specific set of rules on the online platforms, which are both, so the supply chains and online platforms are considered as separate domains where the public legislation, so the legislation made by either member states or the European Union, is intertwined or coexists with some regulatory frameworks that are construed by private parties, such as, for example, the firm that is establishing a supply chain, or such as the platform which is creating this kind of like a fractioned particle economic sphere, like, for example, Amazon, eBay, Airbnb, and so forth. When we look into the rules that were enacted after within this 2018-19 reform, I think it's quite clear to us that European legislation is trying to somehow reclaim its voice as the regulatory power in this more and more diversified, more and more fractioned world of regulation, where the regulatory power, the de facto regulatory power, is increasingly coming to hands of the private parties, of the non-state actors. And perhaps to some extent, what European Union did here was somehow acknowledging or stating the obvious, because it has been claimed for many, many years before that contract law or state-made law is no longer the only, and for sure not the dominant factor in many parts of contracting. For sure, also the emergence of the online commerce and very fast proliferation of various forms of online contracting, various environments for online contracting, further enhanced, further speed up this process, because it even further translated the regulatory power onto various non-state authorities, various non-state actors who act in the online sphere, such as online platforms, but not only. But for sure, what happened during this 2018-19 reform is that European Union law quite clearly stated that, okay, we have this problem of the emergence of new spheres of economy, new ways of regulating these spheres by private actors, and European Union law should also have a say in this world. And I think this is a very interesting change and a very important step forward in somehow changing the face of how private law is understood and how private law is allocated in this pluralistic, diversified world of regulations. And what is also finally worth mentioning here is that this reform also opened new perspectives, new prospects for the distributive effects of contract law, because by dealing with data and by dealing with various ways of using data, in terms of governing, in terms of processing, in terms of, for example, personalization, I was referring to many times before, European contract law was trying to somehow commodify some kinds of data which are on the market, and also in these terms, the new rules may exert some kind of distributive effect, distributive outcomes in the consumer economy. And to wrap it up and to tell you at which stage I finished my paper and which questions I would like to keep open, both in this paper and perhaps also for the sake of our discussion today. So the question, first of all, is to what extent what we experienced within the 2018-19 reform was simply like a cosmetic change in consumer acquis of the EU, and to what extent it can be understood as the introduction, as the first step towards a new perception of private law, both in terms of what I said before, in terms of how private law is allocated within the current present-day normative environment of European market. But secondly, what roles are attributed to private law, to contract law in particular, especially to what extent private law may indeed perform the regulatory function, and whether such goals like sustainability, for example, or data protection should be left in hands of private law, of contract law instruments, and to what extent they should be reserved for state enforced, for purely public law, public based instruments. And further, to what extent what we experience right now regarding COVID-19 and both the, let's say, more constructive outcomes of COVID-19, such as huge proliferation of online contracting, a very clear shift of many forms of social activity, of market activity in the online sphere, as we can see right now, even today from our Zoom seminar. And so to what extent these changes, and also to what extent the negative side of this phenomenon, such as various instances of manipulation, of duress exercised on consumers that we have heard about over the past year, may require further reform or further reconsideration of private law, and to what extent such phenomena, like, for example, a growing tendency towards price regulation, which we again could observe in many member states of the EU, especially at the beginning of the pandemic, when prices for particular goods like medical supplies got very, very quickly very high, and were somehow regulated, somehow framed by particular states. To what extent this sort of phenomena may indicate that, in fact, we are now experiencing, again, something new in private law, some kind of perhaps even like stronger shift towards regulatory approach in private law, in contract law, and whether this tendency was something one-off, and whether it can be considered as a beginning of something of a more stable tendency towards more regulatory and more steering approach in the law of contracts. And finally, this is the question I put here. I do not have any clear answer to this question, and this is something I would be very happy to hear your opinions about as well, is whether there's any place for the classically considered private law or contract law in the digital economy, or whether this kind of hybrid phenomena we are observing right now, so the phenomena where public law is somehow paired, is somehow intertwined with private law, and where public law instruments are used to resolve some individual private law related problems, and the opposite, where private law is employed to pursue some public collective goals. Whether it means that what we will have in the future will be some sort of a new regulatory approach where the distinction between public and private law will completely disappear, or at least will be no longer relevant to describe the kind of rules and the kind of approaches we'll have on the market, or whether still this kind of distinction, and the distinction in particular between parts of law which are based on autonomy, on the classically considered autonomy, and parts of the legal order which are based mostly on some collective goals and state enforcement, will be valid and will be still important for us. Okay, so these are my comments. This was a very brief attempt to sum up what I put in the paper. And thank you for your attention, and I will be very happy to hear your comments, your questions. Thanks.
Thank you so much, Mateusz. Thank you for the fantastic paper and the fantastic presentation. And well, it would be very nice if whoever has a question or any kind of comment, observation, note, if you could, let's say, if we could start with a Q on the chat, and then you address the question directly to Mateusz. I think that would be great in terms of functioning, so that we don't overlap. So, is there any question or comment? Absolutely, Paola. Go ahead. Paola Iamicelli from the University of Trento.
Well, first of all, good afternoon to everybody. I'm very happy to be here. Many thanks to Mateusz, but also many thanks to Mireia for this wonderful organization, to Sebastian, all the colleagues from Pompeu, Fabra, all the other colleagues that we have met in other occasions. So thanks for this chance of sharing our contribution. And thanks to Mateusz for his wonderful presentation, for this challenging paper. I would say, I mean, the first thing that I would like to say is that it is a very challenging paper in the sense that it brings about a lot of, puts together a lot of dimensions. So maybe a first concern that I might raise is that it might be quite difficult to put all them on together and to keep, the depth and, rigorous control of all these dimensions. But I found the presentation, rich of insight, and I'm looking forward to go into that more at ease in the future. The first question I would like to ask you is maybe it's an invitation to clarify whether your statements are more positive or normative. So what you observe around this triptych is the way you think the European private law is moving already now, or the directions towards which European private law should move in the near future. So to clarify whether your statement is a positive or a normative statement, and then together with that, I would put a couple of challenges to you, just because you didn't pick enough, and then let's try to see whether I well understood what you were expressing, so we can debate about it. First thing about the concept of vulnerability, seems to me that if I well understood, that you see the concept of vulnerability a weaker concept that goes more into the direction of a social dimension rather than just an individual dimension of weakness. But my challenge is the following. If we look at the reform of the Unfair Commercial Practice Directive, one of the major points for private lawyers that the array of remedies is reached, and we, let's say, complete the menu of remedies, coupling individual private remedies with the public enforcement that we already had in the previous setting of the directive. So how do we combine the social dimension of this concept of vulnerability with the use of remedies, like, for example, a termination of the contract, that are remedies particularly tailored around the individual position of the consumer? So how do we combine the social dimension of vulnerability with the individual dimension of the unfairness, and especially the remedy that is proposed now by the reformed directive? This is the first, let's say, provocative question to test, to check if I well understood the concept of vulnerability. And the second provocative question is about the concept of autonomy and the interesting link that you posed between consumer protection and the data protection. And here you say that what you see in common is a concept of autonomy that, beyond the efficiency-driven concept that we have already had in traditional views, we gain a kind of focus on self-determination, right? That would put together or combine, consumer protection and data protection. Okay, I don't want here to discuss it to be too long whether we really, protect self-determination through the rule of consent in data protection. This is not what I'm asking you. But what about consumer protection? What are, in your view, the elements that enable us to say that European consumer law is going towards a higher protection of self-determination of the consumer in the, let's say, personalistic way that you propose, or anthropological way that, as you said before? Okay, sorry for being long, maybe. Thank you. Of course, you don't need to answer all these issues, and maybe we can collect more issues from other people that might interest you.
Mateusz, as you wish. Go ahead.
Okay. Sorry, I see there is also a question from Charlotte. Sure. Well, so thank you, Paul and Charlotte, for these questions. And yes, so first of all, of course, I'm fully aware that what I was trying to do in this paper was some sort of a mission impossible, because I was trying to somehow embrace and encapsulate a very, very broad set of phenomena and find some common denominators for various, sometimes very distinct approaches or rules enacted by the European Union. However, I think that even if sometimes perhaps I was looking for some connections or for some intellectual structures which were not planned by the EU, in the sense that sometimes it seemed to me that various parts of this new consumer acquis were not fully integrated together, were not fully coordinated in terms of the underlying concepts or underlying values, underlying structures. I still think that, or at least I thought it might be worthy of effort to, let's say, somehow do the part of the job that Europe, or at least try to do the part of the job that the European Union didn't do. So to build this kind of like more overarching conceptual umbrella over these rules. And with this in mind, of course, what I did here is only an attempt. And but what I was trying to do was rather the analytical work. It was not normative. It was not normative in the sense that I was trying to say, or like, as I said, reverse engineer what the European Union was trying to do through this reform. But I was not trying, or at least only in some like minor parts of the paper, I was trying to express some views how this should look like. So I am myself quite critical about some parts of these new rules. Of course, I am partly critical about what Charlotte wrote about, so about the possible impact of the sustainability-related rules of the new Consumer Sales Directive upon the actual level of sustainability of environmental protection on the consumer market and in the EU in general. I am also quite critical about the regulatory approach that was taken towards price personalization, because I have very strong disbelief in transparency transparency and consent as the effective tools of protecting consumers vis-a-vis this kind of practices and the kind of threats that are associated with personalization. I think I am also partly skeptical about the idea of consent as the principal element of GDPR and protection of consumer privacy and consumer data. But nevertheless, I was trying to somehow establish a more or less coherent picture and build it out of like a kind of a jigsaw, because I think what we had in both the new consumer directives and some other acts such as GDPR is a very, let's say, novel approach towards what is consumer law and how consumer law should look like. And even if these all of the connections, all of the denominators I was trying to identify in the paper do not really exist in the mind of the creators of these rules, they actually exist in the legal order right now. So I think that at least for the time being, before we move into some more coherent normative considerations, it was just worthy to understand what actually happened and what kind of like a new animal, new creature we have in the consumer law after the reform. Secondly, the concept of vulnerability and remedies. Well, I think it's a very good point, Paula, and I do not have. I'm not sure if that was how you understood this possible link between vulnerability and remedies, but I think, and so maybe like one more general, and that will be a normative, not a descriptive claim. I am also quite skeptical about private enforcement in consumer law, in the sense that I do not believe that in most of the societies of the EU, most of the member states, private enforcement can actually work. Or at least that classical public enforcement, so the enforcement where we have the individual consumer who goes to a court or who goes to some administrative authority and brings a claim and pursues this claim. I really don't think this is the way how consumer law can be enforced effectively. And we have many examples from both the case law of the European Court of Justice and from the domestic practice, where in some substantive parts, for example, in consumer financial services, this way of enforcement really failed. But what I believe in is private enforcement, which is somehow supported by the state, in the sense that state provides consumers with assistance, with support, both in terms of, let's say, the cost-related part of enforcement. So, for example, where consumers have some privileges in terms of the cost they have to incur while bringing a case to a court, and especially where the state provides some intellectual support to consumers, where the state supports consumers in identifying the problem in the transaction, in bringing the case to the court, in arguing for this case. So basically where the state provides an easily obtainable legal service for consumers. And from this perspective, I think the concept of vulnerability that I was trying to reconstruct I was trying to describe in my paper is so I do not see much contradiction here, because what I was trying to say is that the notion of who is weaker on the market and who deserves protection is getting more and more broadened in the European Union law, and is understood in more and more extended terms than it used to be classically. So we do not we no longer think about vulnerability, about let's say the power inferiority relation as the purely economic concept. So it's not only the question of information asymmetry, it's not only the question of bargaining power, but it's also the question, for example, who gets information about consumer and how this information can be processed. And like the fact that consumer reveals some information or lets the professional, the firm to somehow interfere with consumers' privacy, in the view of the new consumer rules, seems to make the consumers, seems to be an independent ground for protection, for more preferential treatment for consumers. So no longer the question of economic utility, no longer the question of transaction costs or bargaining power as we used to understand these concepts. And from this perspective, the vulnerability is the question of, especially the question of how, let's say, the market relation or social relation between a consumer and the professional is framed. I think the remedies is a partly distinct question, to the extent that remedies can come to play, can come to the stage only when there is a, let's say, serious infringement of, for example, consumers' data or consumers' economic rights. And here, again, as I said before, I'm not a big supporter of the idea of privately enforced remedies. And I think the vulnerability problem we have at the outset, so the vulnerability in terms of economic power, in terms of some social dependency of consumer, can also be reflected in, or can also translate itself onto the remedies, in the sense that consumers may face some problems or may face some obstacles in enforcing particular remedies. But I think apart from this, these two things are quite distinct for me. But I will have to think it through more. But this is the tentative answer I can give right now.
Thank you.
And secondly, the question of autonomy. So if I understood your question, it was you were trying to understand to what extent the consumer law, but you meant the classical consumer law is providing instruments to protect non-economic autonomy. Do I understand you right, Paula?
Well, actually, no. I was referring to the new consumer law that you are observing and analyzing. To what extent does it support? I mean, if you can give example of cases in which we see that the concept of autonomy is mostly oriented to capture the self-determination dimension that you presented.
Mm-hmm. Okay, sure.
If you...
Yes, of course. So here, perhaps the most clear example for me, at least the instance where the European Union was trying to achieve this effect, so to protect non-economic related autonomy, is the question of personalization. So the question of protecting consumers who do not want to be personalized and who do not want to, let's say, receive decisions that are based on their individual features, and to empower these consumers to let them say no, basically. And here, both when we think, when we look into the new rules on price personalization in the Consumer Rights Directive, and when we look into GDPR, I think it's quite clear for me that this kind of autonomy or this kind of self-determination of individuals is something much more than a simple economic autonomy. Because, for example, when you think about personalized pricing, the personalized price that consumer receives is not always the price that is disfavored to this consumer. So sometimes this price can be lower than the fixed price that can be offered to this consumer by the professional. I think what is the principal object of the principal concern, the principal object of protection here is the individual's sovereign standing or the individual's possibility to self-determine himself or herself and to decide whether the treatment the individual wants to receive from a professional, from a firm, should be the one-size-fits-all treatment. So the treatment which is equal for everybody, or whether the consumer would like to be personalized and agrees that his or her personal traits, some individual characteristics can come into play and can be a basis for market decisions.
Thanks.
Do you wanna address Charlotte's comment, Mateusz?
I thought it was addressed before. Sorry, Charlotte.
Yes,
I said that yes. I agree with Charlotte that the new consumer science directive is, to me as well, some kind of missed opportunity. It does much less than could have been done, and I am not entirely sure whether this instrument may in fact turn out to be effective as a tool of providing safeguarding sustainability.
Okay, we are 6 minutes beyond what we agreed, and I have a question, but I'm not sure there's time to actually address it. So if you want, is there anybody else who has any comment? Yeah, do you give me 2 minutes to ask the question, or you think yes? That's wonderful. Thank you so much, Mateusz. My question, I address it to you, but it's something that I cannot. It really boggles my mind, which is what you said at the end, and it's also in your paper. But it's a, let's say, a fundamental question on how we match the problems that we have with autonomy, particularly in online transactions and with algorithmic decisions. And we know that consumers don't know. We have all the behavioral insights. We know how they take decisions. And at the same time, we continue, even with the reform from 2018, 2019, we continue focusing on consent and transparency, which it seemed to me that you agreed on that. How do we match this when we even know that when it comes to remedies, like at the individual level, don't even work? Like, how do we create this exogenous autonomy that we're looking for, but that it's very questionable that we are actually getting into it?
You are asking very difficult questions, Mireia. I don't know how to do it, and I'm not sure if anybody right now has a good solution to this problem. As you know, in the beyond the EU, so in the US, for example, there is a very strong conviction that transparency is no longer an optimal solution to market inequalities and to consumer vulnerability, consumer weakness, both in the classical spheres of consumer law, but also in data protection. And the Henri Benchahar, whom I mentioned before, is one of the strongest proponents of this anti-transparency movement in the US. Well, as I said before, I concur to large extent with Henri in this criticism, and although I see, let's say, many positive outcomes of the EU concept of transparency, and I see some spheres where the concept of transparency, for example, in consumer financial services, in consumer credit agreements, had some positive impact on consumer protection in my mind. I'm not sure whether nowadays, especially in the online commerce and especially in the spheres of overlap between economic problems and privacy and data protection, transparency is any longer the adequate response. So I think, and again, I left this question pending in the end, but I think that if we want it or not, perhaps the evolution of the EU consumer law will be more and more the evolution towards more public law-oriented approaches. But so the approaches which will be to the, let's say, fewer extent based on on transparency, on this, let's say, classical economic ideas of information asymmetry, and that will be more focused on, let's say, providing some collective responses or general responses to some more structural market inefficiencies or dysfunctionalities. But again, it's another, at least for the time being, another mission impossible. What you are asking for. I don't think anybody has the answer to this question. For sure, the European Commission doesn't have one.
Thank you so much for trying, and we will continue thinking about it. And since we said this seminar should last an hour, I would like, on behalf of the organizers, to thank you, all of you, very much, to thank Mateusz particularly, to give this fantastic presentation and open the floor for what we hope is this, let's say, profitable space. Please invite whoever you think might be interested, and keep this seminar as a place where you could present your research if you want to. I would also like to mention and thank Sébastien Facio, who works at UPF, is a PhD student there, for his fantastic assistance in making this possible, and to all the co-organizers for all the work. And we meet you on June 2nd with Professor Vanessa Maig, and look forward to seeing you then. Thank you very much, Mateusz.
Thank you. It was great to see you all. Thank you, Mireia, for hosting this event and for making this possible. And yes, I'm also looking forward to see you all on the next event.